Blog Talk Radio.
Chapter 1, The Dawn of the Guardian. Title:
Understanding Admiralty Jurisdiction and Clerks' Practices in Commerce. Introduction. In the realm of legal proceedings, the complexities of Admiralty jurisdiction and its historical influence on commerce have often been a topic of discussion. This article aims to delve into the intricacies of Admiralty jurisdiction and its connection to common law, with a focus on the Clerks' Practices document. This examination will provide insight into the civil jurisdiction of Admiralty courts, shedding light on the dynamics that shape legal proceedings and practices. Admiralty jurisdiction, exploring the law of the sea. Admiralty jurisdiction, commonly known as the law of the sea, has been a cornerstone of legal systems for centuries. This jurisdiction encompasses matters related to maritime commerce, both on water and on land, forming a framework that governs various economic activities. While its name suggests a solely maritime focus, Admiralty jurisdiction holds influence over land-based transactions as well. #Unraveling the deception, law of the sea on land. The misconception that Admiralty jurisdiction solely pertains to maritime activities is widespread. This notion has been fostered by the deliberate misinterpretation of the term /law of the sea /. In reality, Admiralty jurisdiction encompasses both maritime and land-based commerce, making it imperative to comprehend its intricacies for a comprehensive understanding of legal proceedings. Clerks' Practices, navigating the historical context. The Clerks' Practices document serves as a critical resource for unraveling the historical development of Admiralty jurisdiction and its interaction with common law. This document is divided into 3 parts, with the first part dedicated to an in-depth exploration of the civil jurisdiction of the Court of Admiralty. #Battleground of Jurisdictions, Common Law versus Admiralty. Throughout history, common law and Admiralty jurisdiction have engaged in a dynamic struggle for supremacy. The ebb and flow of dominance between these two jurisdictions has shaped legal systems and practices. Admiralty courts were favored for their lucrative nature, allowing nobles and lords to establish their court systems and generate revenue. The essence of civil jurisdiction. Central to Admiralty jurisdiction is its civil nature, focused primarily on monetary matters. This aspect underscores the essence of debtors' prisons and provides a foundation for various legal actions. Recognizing the civil aspect of Admiralty jurisdiction is essential for comprehending the intricacies of legal procedures that touch upon both civil and criminal domains. Deciphering penal action. Within the context of legal proceedings, the term /penal action assumes significance. This term highlights the nuanced relationship between criminal and civil jurisdictions. While commonly perceived as distinct, these jurisdictions often intersect, revealing the intricate nature of legal definitions and implications. The significance of the Clerks' Practices. The Clerks' Practices document serves as a bridge between history and contemporary legal practices. Its exploration of the civil jurisdiction of Admiralty courts provides a foundation for understanding the development of legal systems, the interactions between various jurisdictions, and the evolution of commerce-related legal actions. Conclusion. Understanding Admiralty jurisdiction goes beyond a surface-level comprehension of maritime law. It extends its reach into both maritime and land-based commerce, playing a pivotal role in shaping legal proceedings. The Clerks' Practices document, with its historical examination of the civil jurisdiction of Admiralty courts, offers a valuable perspective on the evolution of legal systems and their impact on commerce. By delving into these complexities, individuals can gain a more nuanced understanding of the legal landscape that governs our economic interactions. Unraveling Admiralty jurisdiction and penal actions in legal proceedings. Introduction. Exploring the depths of legal intricacies, this article delves into the concept of penal actions within the context of Admiralty jurisdiction. Through an analysis of the Clerk's Practices document and its historical implications, we uncover the connection between civil and criminal proceedings, shedding light on the underpinnings of modern legal practices. Penal actions, a closer look. Intriguingly, penal actions offer a unique perspective on the interplay between civil and criminal proceedings. These actions, although appearing criminal in nature, possess a civil essence, focusing on monetary penalties as a form of punishment. Understanding the nuances of penal actions is crucial to comprehending the mechanics of legal proceedings that straddle the boundaries between civil and criminal domains. #The myth of distinction, criminal versus civil. The prevailing misconception about a clear demarcation between criminal and civil jurisdictions is challenged when examining penal actions. These actions, termed /penal / blur the lines between civil wrongs and criminal offenses, revealing that legal distinctions may not be as rigid as commonly perceived. Clerk's Practices, a historical lens. The Clerk's Practices document emerges as a historical treasure trove, allowing us to traverse the evolution of admiralty jurisdiction and its interaction with civil and criminal proceedings. This document unfolds in 3 parts, with the first segment devoted to an in-depth exploration of the civil jurisdiction of admiralty courts. #Historical battles, common law and admiralty. Through the lens of history, the Clerk's Practices document unveils the age-old struggle between common law and admiralty jurisdiction. These two legal realms have vied for dominance, shaping legal systems and practices over centuries. The historical tussle between these jurisdictions forms the backdrop against which modern legal intricacies unfold. Understanding civil jurisdiction. At the heart of admiralty jurisdiction lies its civil nature, focused on financial matters. This foundational aspect not only underscores the essence of debtors' prisons but also lays the groundwork for diverse legal actions. The recognition of admiralty jurisdiction's civil facet offers a key insight into legal procedures that traverse the realm of civil and criminal cases. Insights from the Clerk's Practices. The Clerk's Practices document serves as a bridge between history and contemporary legal practices. By exploring the civil jurisdiction of admiralty courts, this document sheds light on the development of legal systems, the intricate interplay of different jurisdictions, and the evolution of legal actions connected to commerce and penalties. Conclusion. As we navigate the intricate landscape of legal proceedings, the concept of penal actions emerges as a compelling bridge between civil and criminal jurisdictions. By diving into the Clerk's Practices document, we gain a profound understanding of how admiralty jurisdiction's civil nature shapes legal procedures that extend beyond maritime activities. This exploration challenges conventional distinctions, presenting a richer, more complex view of legal proceedings that encompass both civil and criminal domains. Unraveling admiralty jurisdiction, contracts, terminology, and legal significance. Introduction. In the intricate world of law, the nuances of admiralty jurisdiction come to light. This article embarks on a journey to explore the criminal aspects of a seemingly colorable admiralty jurisdiction. As we dissect the transcript, we delve into the foundations of admiralty law, its connection to contracts, and the historical evolution of this jurisdiction's terminology. Contracts and admiralty, an unveiling connection. At the heart of admiralty jurisdiction lies a pivotal element, contracts. This examination highlights the intricate relationship between admiralty law and contractual agreements. These contracts serve as gateways, pulling individuals into admiralty's jurisdictional realm. #Colorable admiralty, a complex web. The transcript's discourse unveils the concept of /colorable admiralty, /. This concept signifies the facade of legality within which admiralty jurisdiction operates. Understanding this concept becomes key to deciphering how admiralty jurisdiction can stealthily encroach upon various legal matters. Historical exploration, the origins of admiralty jurisdiction. A historical journey takes us back to the roots of admiralty jurisdiction. Its origin and evolution offer insights into the establishment of titles, such as /admiral, / and their association with maritime authority. ## ancestral anomalies, tracing the admiral title. The history of the /admiral / title traces back through time, interwoven with various cultures and languages. From its early appearances in European history to its roots in Arabic terms, this title carries a legacy that transcends borders. ## Admiralty's progression, a shift in perspective. Intriguingly, history unfolds Admiralty's transformation from a niche maritime concept to a broader jurisdictional domain. This progression resonates with legal shifts and the dynamics between common law and Admiralty principles. Contracts and jurisdiction, unraveling the civil aspect. Central to understanding Admiralty jurisdiction is its civil nature, rooted in financial matters and contractual obligations. This cornerstone offers valuable insights into how Admiralty jurisdiction intersects with various legal arenas. Navigating the Clerk's Practices. The Clerk's Practices document emerges as a crucial historical source for comprehending the multifaceted nature of Admiralty jurisdiction. This document's exploration, spanning historical, statutory, and case law aspects, unravels the intricate threads of this legal realm. Conclusion. In the intricate tapestry of Admiralty jurisdiction, contracts act as the gateway, intertwining civil and criminal aspects. By peeling back the layers of history, terminology, and legal practices, we gain a comprehensive understanding of how Admiralty jurisdiction transcends maritime matters, touching various spheres of the legal landscape. As we navigate the colorful facets and historical roots, a clearer picture emerges, highlighting the dynamic interplay of law and contracts within the realm of Admiralty jurisdiction. Navigating the seas of legal jurisdiction, contracts, terminology, and enforcement. Introduction. In the intricate world of modern law, the interplay between common law and other legal doctrines is a constant ebb and flow. This article delves into the transcript's discussions, shedding light on the dominance of common law and its evolving dynamics with Admiralty jurisdiction. Through the lens of terminology, contract enforcement, and historical context, we aim to decipher the intricate dance of legal principles at play. The evolving dynamics, common law versus Admiralty jurisdiction. The realm of law is far from static, and the transcript underscores the ever-changing dominance between common law and Admiralty jurisdiction. A historical perspective reveals the recurring shifts in dominance, creating a legal landscape in constant flux. ## The pendulum of influence, an age-old pattern. Within the legal arena, the transcript underscores the recurring pattern of dominance shifting between common law and Admiralty jurisdiction. This cyclical ebb and flow has been witnessed over the years, emphasizing the malleability of legal principles over time. ## An analytical gaze, common laws rise and fall. Intriguingly, the transcript acknowledges the periodic resurgence of common law, followed by its receding influence. This cyclical phenomenon poses intriguing questions about the factors driving these shifts and the implications they carry for legal practices. Decoding legal terminology, in rem and in personam. A crucial aspect of comprehending legal matters involves grasping the nuanced terminology. The transcript introduces key Latin terms, / in rem / and / in personam / which serve as foundational concepts in understanding jurisdictional boundaries. ## in rem / peering into property-centric jurisdiction. The concept of / in rem / emerges as a central theme, denoting legal proceedings against a thing rather than a person. Understanding this concept is pivotal in unraveling the complexities of property-centric jurisdiction and its implications. ## in personam / untangling personal rights and obligations. The term / in personam / brings personal rights and obligations to the forefront, shaping legal actions centered around individuals rather than property. This dichotomy underscores the divergent paths that legal proceedings can take, depending on whether they are / in rem / or / in personam /. The enigmatic Court of Admiralty, procedures and terminology. The transcript navigates the jurisdiction of the Court of Admiralty, exploring the intricate procedures and terminology that define its operations. This glimpse into the court's workings offers insights into the unique aspects that set Admiralty jurisdiction apart. ## unveiling Admiralty actions, bottomry, salvage, and mariners' wages. Key components of Admiralty jurisdiction come into focus as the transcript introduces us to distinct actions within the court. These include /, bottomry, /, salvage, / and / mariners' wages, / each bearing a unique significance in maritime legal matters. ## the sphere of attachment, an investigative deep dive. The concept of attachment emerges as a critical element in enforcing legal decisions. The transcript delves into attachment's multifaceted role in binding parties to legal outcomes and exploring the potential ramifications it holds. Conclusion. In the labyrinth of legal principles, contracts act as threads connecting diverse jurisdictions. As common law and Admiralty jurisdiction weave their patterns, understanding the nuances of / in rem / and / in personam / becomes paramount. With the Court of Admiralty's procedures and actions revealed, the interplay between property-centric and personal-centric legal matters takes center stage. Navigating these intricate waters illuminates the evolving tides of legal dominance and the enduring legacy of legal terminology in the contemporary landscape. Unraveling the legal web, contracts, jurisdiction, and liens. Introduction. The intricate fabric of modern law weaves together a complex tapestry of contracts, jurisdictions, and property claims. This article navigates through the transcript's discussions, unveiling the layers of legal intricacies surrounding the concepts of attachment, jurisdiction, and the historical roots of law. By delving into these topics, we aim to shed light on the undercurrents that shape contemporary legal landscapes. Unveiling the essence, attachment, and liens. The transcript delves into the core of legal proceedings through an exploration of attachment and liens. This reveals the mechanisms that propel legal actions and property seizures, forming the backbone of many legal cases. ## attachment, legal seizure and compelled appearance. At the heart of legal proceedings lies the concept of attachment, which involves the legal seizure of property and individuals. The transcript highlights how attachment serves as a tool for both compelling appearance and enforcing claims, providing an essential entry point into understanding legal actions. ## liens, tracing ownership and property claims. Liens emerge as a pivotal aspect of property claims and ownership disputes. Understanding the intricate nature of liens is crucial for comprehending how legal entities stake their claims over property and assets, creating a complex web of contractual relationships. Navigating jurisdiction, admiralty, and common law. The transcript offers insights into the interplay between admiralty jurisdiction and common law, uncovering the historical context that has shaped their coexistence. By deciphering the evolving dynamics of these legal realms, we gain a clearer picture of their modern significance. ## Admiralty jurisdiction, contract-based dominance. The transcript underscores the significance of Admiralty jurisdiction in actions founded upon contract. By exploring Admiralty's historical reach into cases involving freight, charter parties, bottomry, mariners' wages, and debts to material men, a comprehensive perspective emerges on the breadth of Admiralty's influence. ## the common law factor, an intricate balance. Within the legal landscape, the transcript sheds light on the intricate relationship between Admiralty and common law. This interplay is highlighted by the 17th Year Agreement during Queen Elizabeth's reign, signifying an attempt to reconcile disputes and define boundaries between these distinct legal domains. Unveiling historical roots, civil law and modern adaptation. A historical glimpse into legal origins provides context for contemporary legal practices. The transcript's exploration of the civil law's influence and adaptation sheds light on the enduring legacy that shapes modern legal proceedings. ### The Civil Law Connection, Admiralty's Historical Underpinnings. The civil law's historical role as the foundation of Admiralty jurisdiction comes into focus. This connection highlights the enduring influence of the civil law, which continues to shape the legal underpinnings of maritime contracts and related matters. ### Modern adaptation, from past to present. As the transcript weaves through history, it becomes apparent that the principles of Admiralty jurisdiction remain relevant in modern legal practices. The evolution from historical maritime contracts to contemporary legal cases showcases the adaptability and resilience of these foundational legal concepts. Conclusion. In the labyrinth of legal intricacies, attachment, jurisdiction, and historical roots emerge as defining factors. Understanding the nuances of attachment and liens offers insight into the mechanisms that drive legal proceedings, while the interplay between Admiralty jurisdiction and common law unravels the dynamic balance between contractual dominance and historical legacy. Ultimately, this exploration offers a window into the complex world of modern law, where historical origins and contemporary adaptations coalesce to shape legal landscapes. Maritime law, origins, jurisdiction, and legal dynamics. Introduction. The intricate web of maritime law, often overlooked, shapes legal proceedings that extend far beyond the high seas. This article delves into the depths of historical origins, jurisdictional intricacies, and the nuanced interplay between civil and common law. By exploring the transcript's insights, we unveil the evolution of maritime law and its implications in modern legal landscapes. Unveiling historical foundations, Admiralty courts and common law. The transcript provides a portal to the historical roots of maritime law, exposing the delicate balance between Admiralty courts and the common law system. ### Admiralty's Ascension, Protection of Maritime Commerce. Central to understanding the transcript is the ascendancy of Admiralty courts. These courts emerged to safeguard the complexities of maritime commerce, proving indispensable in protecting maritime interests that feudal judicatures of the time could not adequately address. This historical context sets the stage for comprehending Admiralty jurisdiction's far-reaching influence. Common law and Admiralty, Tension and Concord. As the transcript outlines, the relationship between common law and Admiralty jurisdiction is marked by tension and cooperation. The 17th-year agreement during Queen Elizabeth's reign exemplifies efforts to reconcile disputes and define the boundaries between Admiralty courts and common law, creating a delicate equilibrium that persists in contemporary legal landscapes. Navigating jurisdiction, Admiralty's scope and implications. The transcript's discourse sheds light on the jurisdictional reach of Admiralty courts, extending beyond the littoral waters to affect legal proceedings on land. ### Maritime contracts and Admiralty jurisdiction. A pivotal insight is the expansive scope of Admiralty jurisdiction. Through examining cases of bottomry, mariners' wages, and debts to material men, the transcript showcases how Admiralty jurisdiction spans maritime contracts, thus solidifying its historical role as a cornerstone of legal proceedings. ### The role of consular courts, historical glimpse. The transcript highlights the influence of consular courts, particularly in the south of Europe. These courts played a vital role in adjudicating commercial and maritime matters, establishing a precedent that transcended borders and echoed through history. Their significance in the development of legal systems offers insight into the origin of modern legal practices. Complexities of jurisdiction, modern applications, and case studies. Contemporary legal scenarios are illuminated by the transcript's exploration of jurisdictional intricacies, offering valuable insights into practical legal applications. ### Jurisdiction in International Waters, a case study. A real-life case from Miami's maritime legal landscape adds depth to the transcript's insights. The case underscores the intricate challenges of jurisdiction in international waters, showcasing how legal systems navigate the complexities of arrest, investigation, and international boundaries. #Contracts, Deeds, and Sealing, Unraveling the Legal Threads. The transcript delves into the realm of contracts, obligations, and deeds, emphasizing the critical importance of these legal instruments. By highlighting their connection to both common law and admiralty jurisdiction, it becomes evident that these documents are the foundation upon which legal claims are built. Conclusion. The transcript's discourse serves as a compass guiding us through the maritime legal labyrinth. From the historical ascendancy of admiralty courts to the modern complexities of jurisdiction, a comprehensive understanding emerges. The interplay between common law and admiralty jurisdiction, the global influence of consular courts, and the practical applications of jurisdiction in international waters collectively compose the intricate tapestry of maritime law. As legal landscapes continue to evolve, the echoes of history and the dynamics of jurisdiction remain ever present, shaping the course of justice on both land and sea. Unveiling the historical compromise, Constitution and Slavery. Introduction. In this exploration, we delve into the complex narrative of the United States Constitution's inception and the nuanced relationship it shared with the institution of slavery. As we dissect the intricate tapestry of historical compromise, we reveal the concealed realities behind the wording of the Constitution and the protection of slavery. Crafting a pact, framers and compromise. The transcript uncovers a pivotal moment in history when abolitionists and slaveholders converged to forge an agreement that would shape the Constitution's trajectory. Concealing Truths, the Constitution's linguistic tread. A central theme emerges, emphasizing the subtlety of the Constitution's wording. The terms /slave/ and /slavery/ remained unspoken. Yet the document silently safeguarded the /peculiar institution / This linguistic compromise would prove pivotal in the ongoing struggle over slavery's fate. Constitution as Guardian, protecting the /peculiar institution /. The Constitution's role as both protector and perpetuator of slavery comes to light. Far from abolishing slavery, the Constitution's provisions shielded this system from the aspirations of abolitionists. This revelation marks a turning point in understanding the Constitution's dualistic stance. Jurisdictional intricacies, from admiralty to deeds. A deeper dive into the transcript unveils the intricate interplay between jurisdictional matters, maritime law, and legal instruments. Deconstructing admiralty jurisdiction. The transcript offers a window into the fascinating world of admiralty jurisdiction. By examining historical cases involving merchants and mariners, we gain insight into how admiralty courts held sway over maritime matters, even on land. The enigmatic role of deeds. The term /deed/ becomes a focal point, connecting the past with the present. The transcript suggests that these deeds are not merely historical artifacts but are intertwined with contemporary legal frameworks. This insight underscores their importance in shaping legal claims and underpins the legal strategies we encounter today. Revisiting historical cases, case studies and perspectives. Through historical cases and modern scenarios, the transcript sheds light on the enduring legacy of historical compromise and its implications. Navigating international waters, a modern dilemma. A real-world case study from Miami's maritime legal landscape underscores the ongoing challenges of jurisdiction in international waters. This contemporary example emphasizes the intricate dance of international boundaries and legal systems, demonstrating that history's impact persists. Deciphering the mechanics, profit and justice. The transcript's exploration of historical courts reveals the intertwining of profit and justice. Through understanding the mechanisms that enabled lords and barons to run their own courts, we gain a clearer perspective on how modern legal systems continue to generate revenue under the guise of justice. Conclusion. The transcript's revelations serve as a beacon, illuminating the concealed narratives of historical compromise and legal intricacies. From the cryptic wording of the Constitution to the far-reaching influence of Admiralty jurisdiction, a comprehensive picture emerges. As we examine the interplay of historical and modern cases, it becomes evident that the shadows of the past continue to shape the contours of contemporary legal landscapes. Through this exploration, we shed light on the delicate balance of justice, compromise, and power, fostering a deeper understanding of the intricate legal tapestry that guides our society. Unveiling the cryptic nature of legal language, contracts, jurisdictions, and commerce. Introduction. In this article, we embark on a journey to uncover the intricate web of legal language, jurisdictional dynamics, and the underlying forces that shape the American legal landscape. By analyzing the transcript, we demystify the concept of acceptance for value, delve into the nuances of jurisdictional arguments, and unravel the essence of maritime law within modern legal contexts. Deciphering acceptance for value, a multifaceted perspective. The transcript introduces us to the enigmatic notion of acceptance for value, which takes us beyond surface interpretations and into the heart of legal strategy. #, a win-win scenario, balancing the scales. At its core, acceptance for value is presented as a strategic maneuver to navigate the legal terrain. The transcript suggests that this approach provides a unique advantage, positioning individuals as creditors rather than debtors in a debt-ridden system. This intriguing tactic emerges as a potential solution in a landscape dominated by financial complexities. #signature, the pinnacle of commerce. The discussion revolves around the pivotal role of signatures in commercial transactions. The transcript proposes that signatures are the lifeblood of commerce, implying that if individuals cease to sign documents, the machinery of the financial world would grind to a halt. This perspective underscores the profound impact of signatures on modern economic systems. Historical insights, maritime jurisdiction and Rex. Delving into historical contexts, the transcript unveils the historical evolution of maritime jurisdiction and its intersection with the concept of #Rex. #Rex, from maritime matters to legal tussles. The concept of #Rex emerges as a significant theme, intertwining maritime law and legal power dynamics. Historical accounts demonstrate that Rex held a coveted place within the jurisdiction of the Lord Admiral. Interestingly, this control over Rex wasn't solely for rescue purposes but often served as a means to acquire property. #clash of jurisdictions, Admiralty versus common law. The transcript guides us through the evolution of jurisdictional conflicts between Admiralty and common law courts. The struggle for authority unfolds over centuries, from the reign of Richard II to the triumph of common law during the era of Charles II. This historical perspective lays the groundwork for comprehending the legal power play between these two systems. Navigating legal interpretations, contracts, sea, and land. As we explore the legal interpretations outlined in the transcript, we encounter the intricate balancing act between contracts executed at sea and on land. #, maritime contracts, an intertwined jurisdiction. The transcript posits that maritime contracts present a unique challenge in terms of jurisdiction. Contracts made at sea and those involving sea-related activities often blur the lines between admiralty and common law jurisdiction. This interpretation underscores the complexity of categorizing contracts and their execution locations.
All right. Hopefully you guys can hear me. Hopefully I'm coming in loud and clear. Again, somebody just let me know that you can hear me and that I'm coming in loud and clear. With that being said, let me just kind of do a couple of things. Let's see, I'm going to do it like this here. Just bear with me. Technically, been dropping a lot of information this week. I want to make sure that everybody really gets how this stuff goes. We got a lot of new people mixed in with a lot of old people, if that makes sense. And because this is compliance officer training, I have to take everybody to a certain point so they can kind of get how this stuff ties in. Those of you that are in our Bittrex space, especially in Apex Capital, I produced a training video about 6 minutes this morning, put it inside of our feed, and that video was entitled Understanding Syntactical Trust Training and Insurance Documentation. Inside of this particular presentation, I took 6 minutes to kind of explain the framework, just kind of give you some highlights. In the realm of financial insurance operations, a thorough understanding of syntactical trust training and the intricate web of insurance forms is critical. This article dives into the world of automated underwriting software and insurance standards and the comprehensive landscape of insurance forms, shedding light on the complexities and the significance of each component. Under navigating the automated underwriting landscape, greetings to all you readers, it is essential to grasp the dynamics of syntactical trust training, especially concerning implementation of automated underwriting software. This software serves as a vital tool for conducting securitization audits and also ensuring compliance and maintaining the integrity of the insurance operations. But what exactly is the role of the DTCC in insurance standards? Well, the Depository Trust Corporation, Clearing Corporation, otherwise known as the DTCC, holds a pivotal position in the insurance landscape. And this is something that a lot of people don't realize. I cannot stress enough the fact of telling you what everybody already knows. But as compliance officers, you don't have that luxury. You have to know what everybody already knows in order for you to really know how to act. Stand in the Depository Trust and Clearing Corporation's position, which holds a pivotal position in the insurance landscape, directly correlates with the core aspects of the global insurance standards. Right there on their website, they used to post on their documentation the actual set, and I'm actually staring at it now. You guys can't see, of course, what I'm talking about. But when you look at the DTC Replacement Implementation Guide, you actually see the Accord Life and Annuity Standards logo, which is under Global Insurance Standards. Those of you that ever dealt with any type of commercial insurance, especially those of you that are in the trucking industry, you ever seen those certificates of insurance? It has the word Accord, like accordance, Accord, ACORD. It's a blue logo trademark with a red semicircle on the top and at the bottom. And everybody in the industry already knows that everything you do commercially has been insured and reinsured. That's why I talk about DTCC as the reinsurance side and the DTC as the insurance side. And there are forms that they use to convey commercial energy to one side to the other. And so just, a lot of folks don't know that. And when they don't know that, they unknowingly start commingling. So you got to learn how to decode the DTC. And this is why they used to prepare the DTCC Replacement Implementation Guide, which is a pivotal resource in the realm of the DTCC. It deals with the DTCC Replacement Implementation Guide, which aligns with the core, the life and annuity standards. This guide provides a comprehensive insight into the workings of the insurance landscape, revealing how the LEI system monetizes and reinsures. The guide also establishes a connection between insurance practices and the intricate world of financial operations. In order for you to fund a loan, it has to be first insured. And then once the loan is funded, it has to be reinsured. This is the formula for the standardized debt obligations that is being used by the automated underwriting software. The heart of the insurance framework lies within the realm of meticulously crafted insurance forms. See, there's forms. And these forms serve as the backbone for various processes, ensuring transparency, accuracy, and efficiency. Let's explore some of the key forms that shape the insurance landscape. Now, there are forms that deal with property loss notices. As a matter of fact, I'm going to give them to you in the actual format that I did in the earlier presentation so you'll get the real gist and, you won't be lost. We'll talk about the forms like this. You got one form which is dealing with property loss notices. Another form deals with the notice of occurrences and claims. Matter of fact, Gazelle, just bring up the form and then just call it out by number so everybody don't get lost. Okay, so we got Accord Form number 1. It deals with property loss notice. Accord Form number 3 deals with liability notice of occurrence and claim. This is the form that you actually use when someone has damaged you. You're making a claim. That's on Accord Form number 3. You also have Accord Form number 22 for all you guys that are in trucking. You got to have this form because it deals with intermodal and interchange, a certificate of insurance. Also, you got Form 24, which is a certificate of property insurance. For those of you that ever had property and casualty insurance, that's the certificate that comes out. Then for those of you that ever had any type of commercial insurance, especially in the trucking industry, good old Form 25, Accord Form 25, which is a certificate of liability insurance. Then you got forms like 27. Form 27 is actually the evidence of property insurance. And Form 28, Accord Form 28, is evidence of commercial property insurance. Then you have the notorious Form 37. And this is the form that they use to seal the deal opposite. Like after they paid a claim or given lawful legal money, they actually will fill out and do a UCC on a statement of no loss, which works in conjunction of a 1099-C. So when you cancel the debt, you're actually making a statement of no loss. These forms are synonymous. They go together. Also, you got Accord Form 54, which deals with the financial responsibility form. In other words, when you want to make someone liable, when you have a lien against them, then you also use an insurance form under the Accord standards, Form 54. Next, you also have, and it's a bunch of them, I'm just skipping around, all the important ones that I use. Accord Form 75, that's the insurance binder. That's where you go from an indemnity to reinsurance, or transmittal letter, UCC 135 in the letter of credit. Then you got the money transmittal bond. Then you're going to basically bring that out of the DTC through the DTCC with Accord Form 75. That's the insurance binder. You also have Form, let's see here, scroll down, Form 125. And that's actually the commercial insurance application. You know, for those of you that are seeking key man insurance, that's the form we fill out, Form 125. Also, those of you that need general liability insurance, well, that's Form 126. Also, for those that have policies such as annuities where they're pulling capital out and they're funding trusts, you're going to utilize Accord Form 131, which is it's the umbrella section. Also, you have what they call, and this is where you list the assets. And this is a very intricate form that we use. We call it a statement form, but it's really a schedule of values. So that's Form 139, Accord Form 139. Also, for those of you that are dealing with general intangibles, you would probably utilize, and again, if you're filling out a Form 1098-F and you're trying to move value, when you want to insure that value, you're going to use a Form 145, Accord Form 145, because that deals with accounts receivables and valuable papers. You also have, for those of you that are professionals like myself as a forensic accountant, this is the Form 187 for professional liability supplement. This is how we're able to do arbitration. And now we're going to get to some execution forms. Again, I'm skipping around. These are the ones that I typically use a lot, so I'm talking about them. Accord Form 501, that is the surety report for execution. So when we do a money transmittal bond to implement that to the DTCC, we're going to probably do a Form 501 and a 502. A 501 is a surety report of execution. A 502 is a contract bond request form, you know, when we add new fiduciaries to it, when we're dealing with trust. Now, here's another form that should interest you, and that's Form 503. 503 deals with, it's a commercial or miscellaneous bond request form. Then we have the good old Form 504, which is an additional entity. So if you got a trust and an LLC, one was insured, the other is reinsured, you'll probably use Form 504 for that. Now, again, Mr. Bay, I get this a lot, especially in the other classes where I got fiduciaries that are executing the UCCs, and they got, they're trying to basically, stop foreclosures and things of that sort, and they're into what forms they need to fill out. Now you get into what we call the professional forms. This is going to be Form 825. This deals with professional specialty insurance applications for use in management and executive and professional lines. It's an applicant section. So this is how you would induce one, meaning that if you already created a security interest and you want it indemnified, you will use Form 825. Now, this is when these quote-unquote non-professionals refuse to give you their information, like attorneys and police, and you ask them for their bond information, they don't want to give it to you. Well, the form you can start out filling out is Form 828. So that's the fiduciary liability coverage section, which also going to lead, and this is the one that lawyers hate, this is Form 831. And if you don't remember none of the other forms, when you ask for somebody for their bond and they refuse to give you their insurance information, remember accord Form 831, because that's the form you use to go after their bond. This is a professional specialty insurance notice of incident, notice of claim. When you're making a claim, you got this UCCs filled out and you ain't got an 831, well, they just sitting around looking at you like you're stuck on stupid. Then also you got the Form 832, which is for miscellaneous E&O. Those of you that understand what we talk about with E&O. And then, of course, the type of insurance that these lawyers actually have was actually filled out on the Form 833, because this is the lawyer's professional liability section. And this is what you ask for. Now, there's a whole bunch of other forms, because the next set of forms deal with each state. So in your state, you got specific forms for your state, because I'm bringing this class by way of the territory known as Florida. For those of you that are in Florida, and those of you that are affiliated with Bezel Bay and Associates, Apex Capital, and any of the affiliates, in other words, if you're listening to this class, you're tied into this form here, which is Form 172 FL for Florida. What is that form, Mr. Bay? Well, that form is what you're supposed to be filling out if you're trying to revoke an election. In other words, when we talk about the revocation of election, everybody's trying to figure out how they do that. There's actually a form for that. It's called the Florida Revocation of Election to be exempt. And again, there's other forms. We can get off into that. I'm just letting you know. In order for you to really understand the landscape of what's taking place, you got to understand that you're no longer in Kansas anymore and that there's a form for everything. And being a competent fiduciary gives you the ability to navigate. But a lot of individuals that are in commerce, they are swinging left and right in the dark, creating liabilities. They haven't first solidified the insurance, and then they don't understand reinsurance. But they're making all these unbonded claims, these unbonded statements. The public never makes, quote unquote, at least they're not supposed to, make an unbonded statement or claim. So when they're accusing you and saying these things, you're not supposed to get upset. You're supposed to understand that they're saying this because there's a bond behind what they're saying. And if they're wrong, you get to what? He who leaves the battlefield first loses. See, court in the public tribunal is a battle of attrition. And a lot of individuals understand the battle of attrition is the goal of being in a battle of attrition is to overwhelm the opponent to the point where they leave the battlefield. And you got to understand that you can't prove anything. The facts are on the moon. It's not about what you can prove. It's about what you can disprove. This is why understanding that all these individuals who refuse to give you their insurance information are committing insurance fraud. Well, what statute is that under? Like I heard someone say today when they was talking to a quote-unquote one of the powers that be, and they literally rebutted them when we don't see any legal marriage. We don't, where's any case law? It's like you have to cite case law. That's a trap. You recite, this is in direct violation of Title 15 under the United States Code, under insurance fraud. Anytime a public official refuses to provide their insurance information, that is a an open door to file a liability claim against them. Put them on notice that you're putting a claim against their insurance. And because they didn't provide the insurance, that doesn't mean they don't have it. They're just refusing to give it to you. And because they're participating in insurance fraud, all violators of insurance fraud on the Title 15 United States Code is also in violation of CFR 2711. And all violators of CFR 2711 can be forced into involuntary bankruptcy. So when you ask for their insurance information and they refuse to give it to you, you're supposed to, by law, put a UCC on them. And these are the merits. But again, if you don't know, you don't know what you don't know. That's why I keep things in rotation. This is why when we talk, I want the talks to be fruitful. I want it to go forth in a certain direction. I am very adamant about information that's being posted, that I've posted and given and said till I'm blue in the face. I expect that when we do talk, you have at least considered the information that's been given so we can have a conversation in that direction. Because a lot of people who are suffering is because they didn't read the damn contract. And when they read it, they didn't comprehend it. And then all of a sudden, because you have this information, which is the truth, you mentally haven't sold out to it. And when you haven't mentally sold out to it, then this is what happens. The body goes where the mind is. See, I don't expect anyone in the public to change their tune just because you got the truth, because there's a remedy for it. People in the public are waiting for somebody to tell them what to do. So if that's how you've been conditioned all your life, even when you get this information, you're still saying, well, Mr. Bay, should I do this? Mr. Bay, should I do that? What do I do next, Mr. Bay? What do I do? What do I do? And that means you need to study, study, study. And when you think you got it, you need to study some more, because I am not the boss of you. This is your commercial endeavor. When we arbitrate cases, I am taking a bond that I've used to save my family, pay off cases. I even buried a family member with it. So this bond is tried and true. It's been used in a lot of different instances. But I had to first forgive the state that trespassed against me. In order for me to use this bond, I had to forgive the state that went against my estate. And a lot of you guys, you're not ready for that lesson. You just want the remedy. You want it, and you want it now. But you got to understand there are principles. There are polarities. You're not going to see your remedy until you get into a certain mind state. And that's something that I can't teach. That's something that you have to learn. I'm just here to give you fundamentals. There are few fundamentals. There are many processes. See, you're supposed to take what I'm telling you in the aspect of, wait a minute, Mr. Bay been saying all the time that it's insurance and reinsurance. So you mean to tell me there's supposed to be insurance forms just like when you do tax, when you report tax transactions, you're supposed to be sending a UCC. Every time you're trying to move commercial energy from one ledger to the other, especially from the private to the public, it's supposed to be insured and reinsured, because the two don't mix. And this is something that you have to fundamentally practice every day. And the only way you can practice it every day is you got to see it laid out. Like, what are the tax forms that you use with these insurance forms? Keep listening, because I'm going to cover that. Like, we'll go back here. All right, so we done covered all these different forms here. Now let's talk about the navigating of the complexity of the insurance documentation. The intricate web of insurance documentation comes to life through various forms that serve a distinct purpose. For professional liability supplement to the notices of incidents or claims, these forms cater to professional specialists in various insurance scenarios. For instance, Form 831 and Form 831 and 833 are for lawyers and other professionals. Form 825 is for professional special insurance application. Form 501 deals with the shared report of execution of money transmittal bonds. Because, yes, you can actually use 501, report the execution of a money transmittal bond. Now, forms 502, 503, and 504 all deal with the contract bond request. Then you also have the property loss notices, which are notices of occurrences and claims. This actually, when you use those forms, that's where you get the reinsurance. So applying the syntactical trust training in practical scenarios is imperative. Like on your admiralty claim, like when you get to your admiralty claim and you get to that Schedule C on your admiralty claim, and it's talking about the notice of fault and demand for payment, you need to cross-reference that form with what particular insurance form should I be filing in order for me to enforce this admiralty claim. Well, if you cross-reference it, you'll easily come up with a property loss notice and a notice of occurrence and claim and whatever else is pertinent to what we're talking about. It's not hard. See, as the industry evolves, syntactical trust training remains an essential cornerstone of the insurance operations. The guides should serve as a roadmap for compliance officers, also for insurance and professionals and all stakeholders involved in the intricate world of insurance documentation. By grasping the nuances of syntactical trust training, professionals can navigate the complexities of the insurance landscape with confidence, ensuring that compliance and efficiency is being used in all of the decision making. In conclusion, syntactical trust training and the deep understanding of the insurance documentation paved the way for an efficient operations and informed choices in the insurance industry. This guide shall serve as a comprehensive resource to those seeking clarity and proficiency. Hopefully what I'm telling you and what I'm saying to you in this class is starting to resonate. Hopefully some of you guys will look at your paperwork a whole different way. Now, for those of you that have actually submitted your documentation, such as your Apex Capital KYC and 1098, if you're at that point, what's going to happen is based on all the data that you put inside of this underwriting software, it already has stamped those bills of exchanges and they're ready to populate them out. There's going to be a filing that's going to be required, and there's going to be final instructions that you're going to have to be able to implement, which means you need to bring your accounting up to par, this, that, and so forth. The software is literally reacting based upon the information that you petition inside of it. My job as a mediator is to make sure that what you are petitioning can be insured and reinsured. Now, I've given you a lot of information in the first half of this class. We're already over an hour done, just kind of give you an idea. For those of you that want to get in on the fun, want to ask some questions, and you're just listening in, and you're trying to figure out how do I get some, how do I get in? Look, the call-in number is 515-605-9806. The number again to call in, to get in. Where you fit in is 515-605-9806. And again, in the final hour, if you're in the call, if you're not in the call-in by then, it will drop you. Meaning that if you call in, you'll be able to ride through the final hour where I'm going to give folks additional time to ask questions and this, that, and the other. Call in for that. If you're just listening in, then just continue to listen till you can't listen no more. I also have a chat set up, so if you're actually interacting with us and you're on the website, on a computer of some sort, you can actually interact with us through the chat. You can ask your questions through the chat as well. But again, what I'm going to attempt to do is very simple. Drop a lot of information on you in the first hour. I want to see who's retaining it. I want to see who's got any questions. I'm going to call you by your last 4 digits of your phone number. I just ask that, be courteous to others. Everybody may have questions, this, that, and the other. But again, I'm going to go down the line, and if I didn't get to you or if I miss you, I will circle back and come back to you before we jump all the way out there. But I'm going to go down the line, call the last 4 digits of your number to see what's up, what's happening, seeing where you're doing it at, because this is where they do it at radio, and kind of see if you're paying attention. Because remember, if you listen long enough, you'll definitely learn something. So let's jump in, shall we? Caller. Let's see who we got. Caller, last 4 digits of your phone number. Let's see what we got. Okay, there we go. I think we had someone jumped out. Well, I'm hoping I can get them back in. Caller, last 4 digits of your number is 7260. 7260. I'm checking in to see if you got any questions, comments, or concerns over anything you heard up to this point. 7260.
I'm good. I'm following. I'm good.
All right. That's what I want to hear. All right, let's go down the line. Let's see who we got here. All right. Caller, last four digits of your number is 1945. 1945. I'm checking in to see if you got any questions, comments, or concerns over anything you've heard up until this point. 1945. Any questions, comments, or concerns? Going once, going twice. All right, we'll keep on going then. All right, go down the line. Let's see who we got. All right. Caller, last four digits of your number is 9074. 9-74. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
Yeah, I'm following you. What's the name of that book you reading out of with these forms in it?
Actually, this is actually the book that I'm reading it out of is directly out of an Accord form index. And if you are a member, meaning that if you're in the insurance industry and you got a password and a login, you'll get access to it. I got all that stuff. So, quote unquote, they don't like for these forms to get out in the public. But if you want a list, I can get you one. If you're a compliance officer, you need. Go ahead.
No, I'm sorry, but I was going to say I was just going to add that to the little list that I sent you earlier today as a reminder that if you can get that to me. Yep. All
right, good deal. Good deal, bro. I got you. All right. All righty. Let's see. Okay. Caller, last four digits of your number is going to be 5116. 5116. I'm checking to see who's in the mix, man. Can you hear me?
Peace and love, Brother Biz.
Peace and love, man. What's good with you?
All right. My understanding, man, you just bombarded us, especially me, with like a million pieces of information and pertinent information at that. But my question is, when applying for a loan, it's my understanding that it has to be insured and reinsured. And the reinsurance comes from the DTC side of one of those forms. So going forward with a with a loan, those forms, and I would imagine other forms have to be applied or attached to it in order for the validity of the loan to be considered, along with. I just, where I am right now is getting the correct forms to the correct application. I understand that you guys, well, not you guys, but I understand that you have the list of forms to use. My concern is the application. It's a vague question, but it's more of a comment. I'm just trying to follow and wanting you to know that I'm paying attention. Very interested in proceeding with a process that I have in mind. And I'm just trying to get my ducks in a row so it'll be like perceivable, so to speak. So I'm gonna continue because I'm so far behind in this process. I don't know what to do, and especially with my accounting. I'm sorry to say, but I appreciate your efforts in putting all this information out, so that if we do want to continue with the process, we have a way to go without stumbling over too many hurdles. So peace and love, Brother Biz. Peace and love, family.
All right.
Thank you.
All right.
Thank you.
All right. Appreciate it, Brother Calvin. All right. Well, we're going to keep it going then. We're going to see what's up and see what's happening. Caller, last four digits of your number is going to be 6918. 6918. I'm checking in to see if you got any questions, comments, or concerns over anything you've heard up until this point.
Hey, Mr. Bay. No questions. I was listening to the insurance and reinsurance part. I did jump in late. I saw the chart of documents in the video that was posted earlier. But, where are those? Is this accessible through the space?
Yeah, you're in the Bank in the Box space, so you just got to make requests. I get them to you.
Okay. Thank you. I'm listening.
All right.
Trying to learn something.
All right. Gotcha, big bro. Gotcha. All right. Let's see. What's up? Caller, last four digits of your number is going to be 9681. 9681. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
My answer or question was answered with the caller before the last one. Thank you.
Gotcha. Okay. All right. Well, hey, just continue to ride with us then. We'll see what's up and see what's happening. Last but not least, I think we just got, okay. Let's see. Got a caller. Last particular number is going to be 3638. 3638. I'm checking in to see if you got any questions.
Grace and peace, beloved.
Peace and love.
Forgive my absence. I've been traveling. I'm in Manhattan handling some business.
Gotcha. You down there in the city that never sleeps. I hear you, big bro.
Oh, man. The city loves me. I met with the mayor's office, and they love me. So I decided to set up an office out here. So I'm just scouting the city where I'm gonna set the shop at.
Hey, sounds like a plan. Well, hey man, ride with us if you can, man. I'm finna turn up the heat in a minute, man.
You already know. Turn it up.
All right. So, gang, here's the deal. If you understand that commerce has a system, then where does all of this data intersect? Well, it intersects with the agency. That's one of the largest agencies in the aspect of financial holdings in the world. It's the system that you know as the DTC, DTCC, CD company, which is the parent company. And by the way, for those of you that have not actually been back to the website since I told you what was getting ready to take place, it would be to your best interest to visit the DTCC's website. Now, again, for those of you that are in Syntactical Trust, we already know what we've been telling everybody, and we already see the changes. But for most people, they haven't been to the DTCC's website as of lately. And I think if you visit it now versus what I showed you at the beginning of the year, you'll realize not only you're not in Kansas anymore, but this information has already gone into a whole different paradigm. The key to commercial transactions is insurance. The key to reconveyance is reinsurance. So, there is a system that has already been established that if you do accounting, you can offset credits with debits, debits with credits. If you're not playing in that space, everybody that is insured and immune against you. And because they got to keep you busy on the plantation, they're giving you your little tokens to move in the prospective spaces that you are allowed. Notice how I use that word, that you are allowed to move. Now, understanding insurance and reinsurance takes on a whole new meaning when you understand that you have direct access to the Federal Reserve. It's called the local courts. You have a system that's called the Court Registry Investment System. And by popular demand, because I had a fiduciary meeting with Bezel Bay and Associates, those that are with Diversity Holdings Limited, and I think I posted this. Yeah, I did in the Bitrix. I'll read it verbatim just so we're clear. Introducing the fall of this year, which will be ERIS. Now, ERIS is what we use in-house. It's the Arbitration Registration Investment System. So it is like the alter ego to the CRIS. Here's some of the outlines for ERIS. It'll help you understand arbitration and the roles of AAA. We're going to be implementing the study of principles of arbitration as an alternative for dispute resolution methods. Also, they understand the role of the American Arbitration Association in providing arbitration services and establishing guidelines for the arbitration proceedings. One of the major things in establishing an arbitration registry investment system is defining the objectives and the scope of arbitration. See, a lot of folks are still wrapping their brain around the CRIS. And the CRIS has been set up to do exactly what's being done right now. And because of the recent release of AI, the recent induction of data sets, I felt that it was, with my vote and my influence with the rest of the fiduciaries, that we push for a training to train compliance officers in harvesting the ERIS system. And again, everything that you've been studying for has led you to understanding that one system serves the next system. So think about the arbitration registration investment system as your way to convey things from the court registry investment system. They're going to induce this platform in such a way that if you do accounting, you're going to love it. If you don't get into this, you're going to be forever imprisoned and enslaved by it. And I'm being candid. I'm being kind. You don't even understand. Individuals are going to purposely be phased out of certain things because of their refusal to get acclimated into certain wheelhouses, if you will. So again, without further ado, if you're learning something, and if this information is putting you into a certain perspective, then keep listening. Remember, all I'm offering you is the truth, nothing more, nothing less. If you listen long enough, you definitely will learn something. And with that, let me just kind of go back into this whole wave of de-dollarization, because I think there's something that you need to pay attention to.
The wave of de-dollarization, challenges to the U.S. dollar's dominance. Summary. The conversation involves discussions about various financial topics, including using third parties for document submission, obtaining EIN numbers, dealing with credit card accounts, bonds, and operating as an individual banker. The participants share insights on understanding different forms, like SF forms and bonds, while emphasizing the importance of being well-informed and cautious about misleading information. There's a mention of direct express cards for Treasury benefits, along with suggestions for maintaining accounts to prevent closure and utilizing the Treasury Direct site. Highlights. Light bulb. The conversation covers topics like third-party submissions, EIN numbers, credit card accounts, bonds, and individual banking. Light bulb. It highlights the significance of understanding various forms, such as SF forms and bonds, and being cautious of misleading information. Light bulb. The mention of direct express cards for Treasury benefits and suggestions for maintaining accounts to prevent closure. Light bulb emphasizes the importance of being well-informed, asking the right questions, and using available resources effectively. Introduction. Welcome to Investipads, where we delve into an in-depth analysis of the latest news and developments in global affairs, international relations, and technology. In this article, we explore the ongoing wave of de-dollarization observed in various countries and its implications for the dominant position of the U.S. dollar in the international monetary system. As major creditors such as Japan, China, and the UK actively reduce their holdings of U.S. Treasuries, the stability of the U.S. dollar faces significant challenges. U.S. Treasuries debt issuance and major creditors' actions. The U.S. Treasury has been issuing a substantial amount of debt, surpassing $9 trillion in various maturities during the first half of the current year. This represents a notable increase of 23% compared to the previous year. However, a recent international capital flows report from the U.S. Treasury Department reveals that major overseas holders, namely Japan, China, and the UK, have been divesting from their U.S. Treasury holdings. In May, these three creditors held $1.0968 trillion, $846.7 billion, and $666.6 billion of U.S. Treasuries, respectively, marking a decrease from their holdings in the preceding month. China's role in de-dollarization. China's role in the de-dollarization trend is noteworthy. Its holdings of U.S. Treasury securities have consistently remained below $1 trillion since April of the preceding year. This trend is attributed to two primary reasons. 1. Active and passive reduction. China has actively reduced its U.S. Treasury holdings for several consecutive months due to negative valuation effects caused by aggressive interest rate hikes by the Federal Reserve. These hikes led to declining U.S. Treasury prices, prompting China to minimize losses by reducing its holdings. Moreover, concerns about the safety of U.S. Treasuries have risen, particularly following global crises such as the Ukrainian conflict. 2. Financial opening and yuan internationalization. China's progress in financial opening and the internationalization of the Chinese yuan has diminished the significance of the United States in China's foreign securities investment. This shift may also be influenced by considerations of risks associated with U.S. financial sanctions. Factors driving de-dollarization. The trend of de-dollarization is driven by several key factors. 1. Shift towards non-dollar settlements. Countries are increasingly settling transactions in non-dollar currencies, challenging the U.S. dollar's dominant position. Notably, the Chinese yuan is gaining momentum in this regard. 2. Weakness in U.S. banks. The crisis in U.S. small and medium-sized banks has weakened the Federal Reserve's ability to preserve the value of the U.S. dollar. 3. Debt ceiling issue. The U.S. debt ceiling issue threatens the credibility of U.S. Treasuries, impacting global confidence in the nation's ability to meet its obligations. 4. Political division. Deepening political division in the U.S. poses risks to the U.S. dollar's long-term dominance, potentially hindering effective crisis management. Implications and recommendations for investors. The de-dollarization wave's impact is far-reaching and can affect various asset categories. Investors are advised to consider diversifying their portfolios to mitigate risks posed by the weakening U.S. dollar hegemony. The U.S. dollar is likely to maintain its dominant position in the short term due to inertia in global dollar trading volumes and established transaction habits. However, as the global political and economic landscape evolves, the trend of a weakened U.S. dollar hegemony could accelerate. Conclusion. In conclusion, the ongoing wave of de-dollarization presents substantial challenges to the U.S. dollar's dominant position in the international monetary system. Major creditors such as Japan, China, and the UK reducing their holdings of U.S. Treasuries weakens the dollar's position. As the global political and economic landscape evolves, the trend of a weakened U.S. dollar hegemony may accelerate. While the U.S. dollar's influence won't diminish overnight, the shift towards de-dollarization is a long-term evolutionary process driven by the relative decline of the United States' global position. Thank you for joining us at Investipads, where we provide insightful analyses on global affairs, international relations, and technology. Stay tuned for more informative content as we explore the dynamic changes shaping our world.
Good day, good day. You are now tuned into The Vault. Trust Christian, own nothing, control everything. Just wanted to do an episode today. Today's episode is going to be about private banking with life insurance. And so I wanted to do a post with a special individual that we do business with at The Vault. His name is Christopher Holt. Many accolades comes with this individual's title. We do our best to do business with people that, we can do long-term business with. So I'm very excited about being able to have Chris join us in this conversation and move forward. So just really excited about that. And we're going to get him to join here. We're going to have a great conversation. Private banking with life insurance. This is one of our experts. So, Chris, you're live.
Yes, sir.
Yeah, alrighty. Yes, this is about the work, Alrighty, so we're doing this as special on Facebook. We usually don't have the audience that we have from the Facebook to the YouTube with the Vault. And so we're going to do that today. We're going to start out on Facebook, and then this is going to be downloaded and posted onto the YouTube channel, and then as well as the iTunes channel later on. So, Christopher Holt, could you introduce yourself and just, let us know your background? I know a lot of people are interested in the topic, which is private banking with life insurance.
My name is Chris Holt. I've been in the business now for, with the banking side of it, at least for about 10 years now. Experienced in financial services since 1992. So I've been around, came at this a few different ways to finally get to where we are right now.
Okay, awesome. All right, Chris, why are we talking about private banking with life insurance? Could you tell us why that's important for common people to have this type of discussion?
Well, I think for most people, a lot of it is about taxes, being able to save on taxes, also being able to have a structure where they can have a system that can take care of a debt issue. What we realize and what we teach people in our organization is that, those numbers, 40% of all of your dollars that you make go out in form of taxations. That is going to be not just income tax, but that's taxes that you pay on your cable, gas tax, state tax, which is income tax.
Sales tax.
Any other tax you can think of. Taxes are
sales
huge.
Tax. Oh,
Sales
yeah.
tax. Yes, absolutely. All of that is a huge piece of the puzzle that is being just taken automatically from you just by you simply just doing everyday life or making money. After you've done all of that, paid your taxes, paid off your, done the things you go out to eat and do the things that you want to do, excuse me, you're really left with 23% of your total dollars that you have to be able to live on. So what we show people how to do, and with our system and what we have put together, is to be able to increase the amount of money that they're able to save, pay less in taxes, get rid of the debt and the interest that is going out of your pocket that you're paying to other individuals. And with this system, with it being a system that is not taxable to you, and showing you how you can actually become your own banking system, it's something where every household should have it. I don't care what your situation is.
Facts.
Every household should have it.
And the thing about it is, Chris, is this is nothing new. This is something that's been going on since, the 1500s, and when banking was kind of, around with the Rothschilds. Banking has been around. Families have practiced banking, and so this is the form of private banking, and we're talking about it specifically through life insurance, and why this is so important. And so, that's very important. But I guess people want to know is how are people implementing these private banking policies, Chris? Because they're like, okay, we know that there's things that exist now. A lot of people don't even have this in their consciousness. So, how is it that these things were created in order to even do this in the first place? Could you tell us that?
Well, these types of programs have been around now for over 200 years. It's not something that's new. You've got companies like JCPenney, Walmart, Walt Disney was created through these types of policies. There are huge conglomerates that were created simply by a banking policy that they knew how to structure hundreds of years ago. And now these kind of programs now have been modernized to work with just about any family. You don't have to be wealthy to do it these days. Basically, it's something where if you have a representative that you work with that understands the infinite banking concept, you have to be able to structure a life insurance product to where it will fit the system, because not all insurance products will allow you to do this type of a system. When you think about putting this together with an agent, what will happen a lot of times is that they will not understand that they need to take a hit on the commission. So they can't structure the policy they would just for somebody. They have to structure it so that the individual can benefit more on the cash side of the policy. So why do we use life insurance? Why couldn't this be done with a bank or say through any other type of investment? Well, life insurance is the only vehicle that allows you to be able to have a umbrella of taxation where the money you put into it and the money you grow within it, as long as you stay within limitations of that policy, is the only vehicle that will allow you to be able to have that all come out to you tax-free with no limitations as to how many of these policies you can have. There is no other vehicle that will do that.
That's a fact, Chris. We got to say that's a fact.
That is a fact. Absolutely. So if there was, I'm sure there'd be other types of programs out there people would be talking about. But I'm telling you, there is no other system that allows you to be able to do what life insurance allows you to do when it's structured correctly. That is a huge thing. It has to be structured correctly.
Okay, and that's how it's done. Is it structured correctly? So that means you're like, how many agents do you think are out there like you, Chris, in the United States right now?
Oh, jeez. I'd say probably less than 1,000 nationally. I would say that actually would do these types of policies and understand them, the inner workings of them. There's less than 1,000, over 1 million agents out there, but most of them are just simply selling you insurance.
Chris is amazing. Chris said 1,000 agents. Chris is one of 1,000 out of 300 million. Thank you, Chris. I'm in good company. I like being in rare company, man. You know,
you're in rare company, man. It just don't happen.
Yeah, that's awesome. I would like to think of myself as in the top 1,000 of what I do, but man, I mean, the numbers for what I do is different. But geez, I mean, that's awesome. So it's how it's structured, and that's what makes you so unique. So,
right.
How do we get involved with something like this if it is at the level where, you know, I got to go to a special guy? So now we know that you're the special guy, you're the legal guy. You know,
right.
How do we do it?
Well, the first step is to get a snapshot of where you are. One thing that we do is we do a data sheet on everyone, and we'll give you a picture of your individual situation, because everybody's situation is different. Not everybody is going to fit this system. It's just simple as that. You've got to have some discipline in place. You got to have some discretionary income in place. There's different things that you've got to have in place in order for this to even work for you. So, and you've got to qualify for it. It is life insurance. So we've got to do a data sheet on you to find out your individual situation and see how the numbers would work for you. That is the first step. You can request, of course, a data sheet from me. You can email me at info@ffecorlando.com. That's info@ First Financial Education Centers Orlando.com, ffecorlando.com. And just request the data sheet. I'll be happy to send that out to you. Also, there's a little presentation I send out to you, kind of explain to you how this works, give you a basic synopsis of creating your own family banking system, and gives you a example in that presentation of how it worked for a family that we call Mark and Joyce in this presentation. So we try to basically educate you on the system, whether or not it is for you or not. My whole thing and my company's goal is to educate you first and foremost, so that you make an informed decision. This is not just about putting you into something and you have no clue what this is. That's not what we're about. Any and everyone that I talk to, they understand the inner workings of it, because I'm constantly grilling them on, okay, well, what's this situation? What should you do when this happens? What should you do when that happens? They can almost tell me how it works. So by the time we're done with you, and before you spend a dime, you will know exactly how this can or cannot work for you.
Info at First Financial, what is it, Education Centers?
Yes, ecorlando.com.
All right, I'm going to type it into the chat for people that didn't hear it. Orlando.com?
Yes, sir.
All right, cool. I typed it in the chat, everyone. It's in the chat. Info at FECOrlando.com.
Yeah.
And so, all right, Chris. We do have a question for you. I want to get to it, but yeah, Chris. So the thing about it is, okay, they have to, pretty much know where they are, and I think that's a big issue in the marketplace to address out here nowadays. A lot of people don't know where they are, man.
Right.
And I really do want to do an episode about, people not utilizing the debt.
Right.
I think that me and you can have a great conversation. There are a lot of people losing household capital income, wealth for their children's education, for their own education is being lost because they don't use private banking. And and a lot of people don't understand it's not, this isn't colloquial, conventional, go down to some bank and get your insurance policy stuff. And I really do encourage people to think about that is when you have when you're paying for anything, you are practicing a form of banking. And point being is the banking that we're talking about is private banking and specifically family household banking on a daily basis. And so I think that a lot of people, they try to separate banking like, oh, that's the bank and then this is me. No, your family household is operating as a bank. There's money that comes into that household. There's money that leaves that household. Exactly. And by money leaving that household, there's a form of money changing going on, in and out, cash flow, all of that good stuff. And I just really want people to really understand that, there's a different way out there.
Absolutely.
And there is a way that's being practiced. And like you say, knowing where you are can really enable you to say, okay, this is where I'm at, so I can institute a banking policy.
Right.
This is just where you are. It's not because, you're anybody special or anything like that. It's because you just implemented the policy. And that's the biggest thing is how many people are going to institute the policy. I guarantee you everybody on this line or most people are going to get cash flow. They're going to get cash flow for sure. They're doing business. I mean, there are people listening to this that make thousands of dollars a month. Thousands of dollars a month, and that money is not being insured. Ladies and gentlemen, if you don't have insurance on your company, that's the business Warren Buffett is in. He's in the insurance business. So I think it's very misleading when individuals don't understand why companies do corporate buybacks.
Yeah.
When you hear these things in the public, these are forms of insurance on themselves.
That's correct.
So, I want you all to understand that from everything is finance. Everything's based. If you got money, you're in finance. What do I need to go to school to get a degree for it then? You know what I mean? Everything's finance. We've been dealing with finance since you got your money from your parents for the birthday gift.
Yeah.
If you don't save it, what do? You spend it or you lose it. I mean, it's not too many legal financial terms we need to know here. But for some odd reason, people go to school, get a 4-year degree, and they still don't know what they're doing with their life.
Yeah.
And we're talking about financial tools, financial mindset, financial strategy, and people say, "Oh, I'm doing well." So, what if you can put yourself in a position where you're actually practicing what all of these are practicing, which is private family banking, private banking? You see it across the board. You see the Rockefellers. You see the Carnegies. You see, like you even explained, Disney. You see individuals that started these companies. They understand internal private banking tactics. That's it. They understand the rules. They have pieces of. I remember when I first heard one of my mentors, he said, the difference between people that are educated or uneducated, he said, is rich people know which tax forms to fill out and which ones not to.
Right.
It's that simple.
That's pretty much it.
So if you all haven't been educated on the same documents that came out at the same time, whether it's trust documents or whether we're talking about insurance, it's all imperative to get that information. That's it. And we're speaking to a very niche and select audience. Everybody's not out for wealth building, wealth generation. But, when someone can tell you, hey, it's less than 1,000 people in a country of 300 million people that, I provide a particular service that is very valued. Like I say, it's encouraging to see, wow, there are still very specialized people in specific fields that we're talking about policies now. Like everybody's heard about life insurance. It sounds good, I might have to get health insurance. But, oh, my gosh, now you're telling me I can do it, and it's banking involved in it? Well, I never heard that before. I never knew about that before. So I understand that that's the case, but, you know, like the mentors used to say, well, you don't know what you don't know.
That's right.
So, you know, there's many things that we don't know, ladies and gentlemen, and I think that being open to learn those things are very, very important. So, you know, can you paint a picture for us, Chris? What does this look like when a person is involved with you?
What does it look like? Well, I can tell you the end result of it.
Right. That's what we want to know. What are the results?
The end result is that you're going to have a system in place for yourself that, on average, if you have a mortgage, you have car payments, you've got student loans, credit card debt, furniture bills, any other debt that you're paying interest out into, you have a system here that is, on average, is showing people how they can pay all of those debts off within 9 years, and still have a substantial amount of income available to you that on a tax-free basis from the system that you just paid off those debts through. There is no other such thing out there in the world that allows you to be able to do that. I'm talking about you being able to use your money in more than one place at the same time. There is no other system that allows you to do that. And I can show you how that works with life insurance. Life insurance is the key. There's no secret here. Like someone's getting out here telling you, hey, you need to use these types of life insurance policies. And people usually cringe when they hear life insurance. Oh, God, I'm trying to know life insurance. That's because they have no clue of what life insurance can actually do for them. And I'm not talking about when you die. I'm talking about you using that insurance while you are alive tomorrow or the day after you get approved for it. So this is a system that when you really understand it, you will understand that there is nothing else out there like it, nothing at all that can do what it does, nothing else. And if you really understand how to use it, it is a absolute wealth building system that can be used and has been used, again, for over 200 years. Very large, very wealthy individuals have used this very same system. And it is now, I'd say, within the past 8 to 10 years, it has been something that has gotten more into mainstream. But when I say mainstream, I'm talking about those who to that education. Because a lot of people just aren't in that realm. So that's why you haven't heard of it, because you just haven't been in that realm. But you're here now. Those of you who hear my voice, you are here now, and I'm very savvy on these types of policies. But that's what you would be left with here, is something that's going to give you the benefits of being debt-free, have a system that you can create tax-free income for the rest of your life. And not even talking about the death benefit part of it, have a legacy that you can build for your family for you doing this now while you are alive.
Hey, Chris, I got a good story for you. I remember when one of the mentors, we were in the environment, they're doing the teaching and everything, and one of them said, so basically you could spend down the entire policy, and then literally when you pass, it gets filled back up for the next generation.
That's pretty much how this can work for you. Do it right.
Chris, when they said that, I wasn't even caring about the numbers, man. I'm being honest, everybody. I just said I knew everybody in the room was telling the truth for a lot of different reasons. But when I heard them say that, I think, I'm a concept person. So I heard the concept, and I was like, all right, I got to think he didn't stutter. And then they kept going. And no one questioned it. I was like, there's a lot of smart people in the room. I like being in a room with people that are smarter than me. There's a lot of educated people in the room. I was like, man, this is a smart environment right here. And this man said you could spend all the money down. I was like, okay, I'm going to check the numbers back a little bit later when I can sit there and crush numbers. So I did it later. And then I came back, and I was still in the environment, and it was always the same type of thought process. It was the same conversation. You could spend it down. I'm like, so you're trying to tell me, how come no one knows that you can spend the policy? Then I found out, well, people don't have this policy. That was the first thing.
No, they don't.
So of course, they didn't have the policy. But no one ever talked about it like that. But these guys, everyone in the room, I mean, pretty much once you get in the system of trust, you already know. You should be going into the banking system, with this type of stuff. And so when you're in the trust environment and people, that was one of the things, man, these guys were wheeling and dealing in the room. I know the guys that originally taught me the information. I mean, these guys are putting out content right now out of the wazoo of just how many people they're helping to really get going in the system. They have they're really big on what you're talking about, which is paying off the debt, getting people really debt free, utilizing the banking system. And I mean, I have never met one person off the private banking system. And I mean, of course, it's not like a million people that I've met off the private banking system, but the ones that have truly implemented the private banking system, I mean, they've never left it, and these people are all financially okay. And it's just like, wow, that's just a difference in them doing bookkeeping every month in their private banking in their house.
Yeah.
It's just them making sure they're putting money in a specific place, getting back a specific role. One of the things I like about even the insurance, guess what? Here, why is it so predictable, Chris? Why is it so predictable? You know what I mean? Like, it's so predictable, man. It's like when people sit here and say, oh, how do I get successful? How do I get wealthy? How do I get money? I sit here and I say, there's got to be a formula. I've read way too many books. I'm like, there's a formula. And I know the formula, but this is a part of the wealth formula. Am I right or wrong, Chris?
You're absolutely right. Absolutely right. And one reason why it's so predictable, it is we're using a predictable product. The product
is insurance. The product is reinsurance. I hope you guys are picking up what we're putting down. I hope this information isn't going over everybody's head. I hope you understand that understanding how this platform, in conjunction with the automated underwriting software, provides you a predictable roadmap. Arbitration is like the way things are put in place as far as framework is concerned. Arbitration is the positioning of the players. Arbitration allows those players to determine who's the settler, who's the beneficiary, who's the grantor, who's the trustee. The arbitration proponent is the set up. The insurance is for the well-being and for keepsake. It creates perpetuity. So when you combine all of that with operating under trust administration, this education puts you in a whole different aspect of thinking as far as implementation is concerned. LoanDisc is what we're using for the automated underwriting software. I have been engaged into a couple of other spaces with that, but for most individuals, it's a matter of just logistics. What is happening based upon how you guys are doing your KYCs. And yes, if you are at the part where you have been asked by the algorithm to submit a KYC and a 1098F, then you're ready for implementation in that regard. But everybody's situation is different. See, that KYC is them identifying you in the DTCC system. And that's where the rubber meets the road for a lot of folks. Because, see, I can only lead you to water. I can't make you drink it. I can only let you know that there are certain things that you have to technically have in order to be in a formidable position, if that makes sense. And again, I hope you're really gathering this information the right way. The wealth building system is insurance and reinsurance. But again, I can't give legal advice. I can't give notarial advice. So if I had a notary that was asking certain questions, I might can indulge some of you guys into certain things. Because usually when we start having these type of conversations, people kind of just want you to just, kind of give up the goods, which I don't mind doing. But you have to ask certain questions in order for me to really know, are you retaining it? I mean, it doesn't do me or you any good if I'm explaining something intricate and you're still on first base and I'm already on third base. So it's understanding this from a 30,000-foot view to a 3,000-foot view to a 3-foot view. And again, think about arbitration as your way to do whatever it is that you're fathoming, you're kind of contemplating. Can I do this? Can I do that? I got to use arbitration to do it. I got to use arbitrage. All right. When I use arbitrage, what forms do I fill out? What forms do I use to bring forth the right insurance that will allow, after this deal is funded, to stay perpetual? That's reinsurance. If I'm able to come into this deal with a business plan and projection, there are things around you. Like we talked last week about the USDA, literally having a business plan put together, utilizing the insurances and the UCCs to leverage credit. And there's a whole lot of things we can get into. But again, I don't want to give a baby a shotgun. I don't want to talk over anyone's head. So we got about 15 minutes left. Yeah, I'm going to go ahead because I got a couple of things I need to do. I am working the algorithm, as you can tell. So 15 minutes left. If you got any questions, call in to 515-605-9806. I'm going to call the last 4 digits of your number to see if anybody got any questions, comments, or concerns before we definitely jump out of here and jump into some other things. Let's start with, caller. Last 4 digits of your number is going to be, let's see what we got here, 9074. 9074. Touching you again to see if you got any questions, comments, or concerns. Can you hear me?
Yeah, I can hear you, man. Hear you loud and clear. In fact, got a bunch of questions now. You woke me up.
All right, talk to me.
This might be a vague question, but I think it is. I think other people probably got the same question in terms of what type of trust would be the optimal vehicle for us to be moving in.
Okay.
Specifically for me, I already have my living trust established, but I'm seeing it's like they're not really respecting it, I guess, from the asset protection side. And I guess that's the weak point or the penetrable point of a living trust, because it's the same or a similar name as mine. So they don't really see, or they're questioning the title transfer.
Okay. So you are a notary, correct?
I got everything submitted. I'm just technically in limbo. But yes.
Okay, so when you say you got technically everything in, tell me what you mean. So before I break this down to you.
I passed all of the classes, and I'm just waiting for the search and everything to get official.
Gotcha. Okay. All right. So I'm going to treat you as if you're already a notary.
Okay.
Now, there are over 90 different types of trusts. And if we get into specifics, there are actually over 250 types of trusts.
Mm-hmm.
When I say trust, make that synonymous with insurance. So there's over 90 different types of insurances that you can use to do whatever it is you're trying to do. The trust becomes the bylaws, the groundwork. The great thing about operating in a trust, as long as you don't violate the bylaws of that trust, that is the law that governs you, because the law makes, the contract makes the law. Another word that's synonymous with trust is contract. Now, I'll talk very elegantly about trust and make it sound real complex and real fly and everybody get all warm and fuzzy, but actually a trust is a contract. That's another definition of it. So, there is 250 different combinations of insurances that allows that trust to act and be what you want it to be. Now, go back to what you just heard in the training with my mentor, Sharif. A trust with insurance gives you the ability to use the money 2 different places at the same time. I want you to think about that. If you got $1 million in life insurance, you get to use that $1 million in 2 different places at the same time. I want you to fathom that. I want you to think about that. I want you to think about, how can I make that work? How can I make a life insurance policy that's valued at $1 million? How can I use that 2 different places at the same time? I'll give you one that most clients are trying to wrap their brain around as we're saying this. Yeah, we got the scary line, but he didn't ask the question. If I got $1 million in life insurance that means technically there's a third-party company with a AAA rating that says that I am worth $1 million. My life, my future labor is minimally worth $1 million. How can I use that value? Well, they've already insured that value. Can I convey that value to someone else in exchange for goods and services? Of course you can. You just got to set up the what? The right type of insurance, the right type of contract, and the right type of conveyance. Once I'm able to get this third-party company to say that I'm worth $1 million, they can say I'm worth $1 million in two different places at the same time. I'm not worth $1 million when I'm dead. I'm worth $1 million now. And I'm able to take what I'm worth now and hedge that, leverage that. Think about this. When you go to work for someone and you're a W-2 employee, you're believing that you're going to a job, you're getting on the clock, you punch the clock, you work 8 to 12 hours, you produce. Listen to this, y'all. You produce. When you go and punch in, if you went to work today and you put in your 8 to 12 hours, did they have to wait for your performance? Or when you punched in, you performed, right?
Right.
Okay. So most red-blooded Americans, when they work, they give up their substance first, and then they wait 5 days, 14 days, some twice a month, some once a month. But the corporation enjoys what? You punching the clock and what? Performing. Insurance is based upon what? Performance. So if you can go to a job and work all week and produce 1,000 widgets and only get paid $10 an hour, $20 an hour, hell, $100 an hour, but you produced a widget that cost $1,000 and you did 1,000 in a week, is that equal exchange? The most valuable thing you gave up was what? Your time.
Time. Yep.
And they insured that time. Listen to this. They insured that time. And they made sure that they're guaranteed to give you what? Your minimal wage. Nobody that's working a job never asks, well, what's the maximum wage? We always settling for minimum wage. This job minimally pays. Well, what does it maximally pay? See, when you start talking like that, you don't become an employee. You become an associate, a partner. Partners talk like that. So in order for you to use that $1 million policy in the same place, two different places at the same time, you get to pick where you want this $1 million to benefit you. So if you're trying to buy a car that's worth $20,000 and you got a $1 million policy, ain't that a big difference?
Yeah.
Shouldn't you be able to pledge a part of your life insurance to acquire that vehicle? Well, what if I told you that's exactly what happened when you signed that application? You created it out of thin air. They just monetized it for you and insured it for you and reinsured it for you. And you agreed to pay it back. You follow me?
Following you, yep. So,
what was your question again?
You answered it. You answered it. Okay. You gave me some food for thought. One other question, man. I have a client that's trying to get a loan, and they have a nonprofit, and their nonprofit is a little different than say. I have a friend of mine that you know too, the guy with the arbitration award that I was telling you about. He has a nonprofit, but his nonprofit is more set up for he's buying, trucks. It's a trucking company trying to help, with the recidivism rate and stuff of that nature. So I can see where the money is going and the assets is being, trying to be procured with his deal. But this other nonprofit, it's like they doing they are really doing charitable work, and it's like I don't see where the money is. They're giving money and giving
let me flip it around. The charitable work that they're doing, what work are they doing?
Kind of the same thing. It's not like buying the assets and training these individuals.
Let's talk. So they are in buying what? What are they buying?
That's a good question, man. I've been having their package. I looked at it maybe 2 weeks ago, and the guy texted me today, and I was telling him, let me get all of my stuff cemented, and then I would get back with him. And because I had you on the phone, I said, let me try to probe you for something to tell them, because I don't see how, with them not having anything but their energy, and I'm not discounting their energy, but just from a banking
just getting
standpoint.
insured. Like if they got a company, the company has general liability insurance. That's the substance. That's what's going to base the loan.
Okay.
That way we don't get into an undiscovered. Like the easiest loans to fund are the ones that if somebody else would say, well, you know what, this person has $1 million life insurance policy, they got $1 million general liability insurance, and they got a $5 million key man policy. Now, when you got all that, it's real easy for you to get loans and finance.
Okay. Got you. Because I just heard you say that having a business plan was a part of, that package.
You gotta do projections. Like, and right now the requirements are, it ain't about what you did in the past, it's about what you will do in the future.
Right. And I was telling them they're gonna have to ramp that up.
Right. Definitely.
Gotcha, man. Thanks for asking the question, man.
I got you, big bro. I got you. All right, let's move down the line, see what's up, see what's happening, see where everybody doing it at, man. All right, let's see. We got caller. Last four digits of your number is going to be 5116. 5116. I'm checking to see what you got for me. Any questions, comments, or concerns, or anything you heard up until this point?
Peace and love. Peace and love.
Peace and love.
No, I don't have any questions. I don't have any comments at this point. The insurance and the arbitrage. Yes, I do have a question.
Okay.
The arbitrage, a certain case or a certain situation would require just a basic request.
All commercial transactions can arbitrarily be resolved, petitioned, conveyed, and assigned. So arbitrage allows arbitrary means and methods to convey commercial energy. So if it touches commerce, arbitration can be used.
Okay, so
we're going to hear, listen to how I'm going to say this.
All right.
As an arbitrator, everybody's going to tell me, well, the bank is evil, they stole my house, the car people are evil, they know I couldn't read, whatever the case may be. 99% of most people's problem is that it was all good just a week ago. Now, even though the contract was bullshit, you was happy until you couldn't keep up and be in honor. So, and I'm using that as an example. As an arbitrator, that sounds good, but that means nothing to me. All I'm concerned with is there's a contract, there's a value, somebody hasn't been paid, somebody wants to be paid. My job is to determine, well, what is that payment, who needs to be paid, and now it's my job to make all parties whole. And people who are still stuck in the gap don't understand, well, how can the person who defaulted be made whole? That's because they don't understand accounting. See, they think that money travels through wires in a wall. Like you press a button, money goes through a wire from my computer to the bank and this, that, and the other. They don't understand that it's credits and debits. They don't understand that there's commerce and accounting. They don't understand that the whole gig is if I can get that person who gave you $1 million life insurance policy to also put in their documentation that you're an accredited investor, that $1 million should be used as a form of accreditation. When you're an accredited investor, well, guess what you can do with that life insurance policy? You can probably pledge out of that $1 million at least $500,000 of that to go buy you some Berkshire Hathaway. When you get Berkshire Hathaway as part of your portfolio, they open the door for you. Now you're going to get A credit and this, that, and the other, because this is what Harvard attorneys and lawyers are told. In order for you to really transition to private, it's going to cost you about $500,000 to $700,000. Keep in mind, y'all, so there's ways to do this. You guys got 30 more seconds before it locks everybody out. So if you in, don't disconnect, because if you disconnect, you will get dropped. But technically, all scenarios commercially can be arbitrarily conveyed.
So if a person had an intellectual property that conveyed 1.5% a day, how would that individual be able to leverage a $10,000 loan to pay that debt back at $680 a day, whatever?
Okay, so let's talk about it from an accounting perspective. All right, how much money does this person make a month?
The person monthly probably makes $4,500.
Okay, so if you make $4,500, you can't spend no more than $450 on that loan a month. If you spend more, you're spending more than your 10% disposable income. So to answer your question, you need to pledge enough insurance where you're only out of pocket no more than $430 a month. The insurance makes up the difference. So let's say, for laughs and giggles, your payment is $600 a month. You're going to come out your pocket $420, and your insurance is going to pay the difference. And your insurance can pay the difference through trust when you convey a K1 every month for that difference between your $420 and the $600 that they require. You kind of act. I don't went past the scary line because I'm trying to show you something. Insurance can be leveraged a lot of different ways.
All right.
To meet that obligation.
So the arbitration would involve
telling the settler, telling the debtor, telling the players the terms and conditions of conveyance. In the aspect of loans, I'm going to be real specific. I have an agreement with Go Capital and North Avenue Capital where they have agreed with their loan products that if you bring a life product, that they will use that life product as collateral, and they will finance the money transmittal bond of 1% of that bond to finance your deal. Quote, unquote, if you need a loan and you don't meet the requirements, but you have insurance, that insurance is pledged, Go Capital finance that loan. We provide, as a loan officer, a money transmittal bond that they hold as collateral. And when you don't pay, they cash out the money transmittal bond.
All right, thank you. I appreciate the information. You answered my question. I appreciate it, Brother Bill.
Okay, bro.
I'm trying to get busy on it.
Okay, good deal.
Submit to your format. Thank you.
All righty, big bro. All right. Let's go down the line. Caller, last prediction, your number is going to be 9681. 9681. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
No, sir. Every question I had, you guys answered it.
Okay. All right. That'll work. All right. Let me go down the line. Let me see who we got. Caller, last prediction, your number is going to be 7260. 7260. I'm checking in to see if you got any questions, comments, or concerns of anything you heard up until this point.
I think I'm following. And
okay.
I always, because it seems simple to me, but not so simple, I have to confirm. Simply put, my candidates just simply need to be alive and breathing.
Correct.
Have some insurance.
Correct.
A business or want a business, right?
Correct.
And the rest of the dots fill in, right? Through the arbitration.
Correct.
So, If they can't read or write and have a vision in their mind of what they want to do, then we come up with a plan, right?
Right. We got to put one together.
Okay. Okay, that's all.
Gotcha. All right. Going down the line. Let's see. Caller, last particular number is going to be 0199. 0199. I'm checking this if you got any questions, comments, or concerns of anything you heard up until this point.
Hello?
What's up? Can you hear me?
Can you hear me?
Loud and clear, big bro. Loud and clear.
Okay. So I guess my question more so was, I actually had one and it's left my mind, so I was listening to what the sister was saying. But you had made a statement before. This is not about the insurance, but you had made a comment one time in one of our classes, and you were saying that the purpose of that you have this $300 million bond, and the purpose of the bond is basically to help those of us that are coming through this process, because you need or its purpose is to help individuals as they're transitioning, right? Mm-hmm. So I guess in our transactions or as a supporting bond in our arbitration, procedures. Mm-hmm. So with all the things that you do for all of us in the vast ways that you do, mm-hmm. you never speak about like compensation. I mean, you say pay for service, but you never speak about compensation. So like in our transactions, once we start getting through this securitization audit, and we're starting to do kind of getting to the places that we want to go to, I mean, is there like a love offering, or is there like a commission that could be paid to you or your organization or your foundation, for the things that you're doing for us? Like I've been kind of wondering that for a while now.
Mm-hmm. Okay, so here's usually how I handle compensation. As a fiduciary, if I have to articulate compensation, I'm not doing my job. Because if I do my job, I will be compensated for performance. And if I'm doing the accounting, I'm making sure that I and my family are being taken care of in that process. Sitting on a panel of about 15 to 50 different fiduciary houses kind of gives you an interesting position. Now, a lot of people move based upon what I say, how I feel, how I act. So I have to say and feel and act a certain type way to get certain things going. Like a gentleman's offer would be, I would love to let you know that, okay, it's going to cost 15 ounces of gold, 20 ounces of silver, but everybody's not ready for that conversation. So what happens, I have to literally leave compensation to a proponent where if I'm being compelled to perform, I provide the mechanism to perform. And then upon performing, compensation, which shouldn't be a question, is made readily available, because I'm simply passing a credit and or debit that was handed to me to the entity or individual who needs that service. So if my needs are being taken care of, like when I arbitrate cases, like this is a very interesting scenario that I'm glad you brought up. People who haven't gone through training, well, Mr. Bay, can I pay you out of my award? No, you can't, because you're using the indemnity bond. That's for my family to make this happen. So that's a conflict of interest. You remember this? You remember in the movie Cadillac Records, and Muddy was talking to Wolf, and the white guy was telling them, man, you keep coming to him like a slave, he's going to keep treating you like one. He said, well, don't you want an advance on your record? No, just pay me what you owe. I don't want to borrow against the store. Right. Pay me what you owe. So if you go publicly to an institution who does half the services that we do, and we charge a third of that, then compensation and this, that, and the other really kind of is moot. I provide a fee service, but I typically deviate from it a lot of times because I'm trying to what? Help everyone. Now, individuals who understand LBOs and they know how to do M3 conveyances, well, they pay me with lawful legal money because they know how to stand on it. They know how to convey it. I would love to take instruments from everyone if you know how to write one, but if you're asking me how to write it, I already know what that is. That's why it's about insurance and reinsurance. So inside of the reinsurance and insurance, there are a lot of things that can be done, and a lot of contributions can be made to my favorite charity. I hope I kind of answered your question.
Yeah. Okay. So I just remembered the first thing that I wanted to ask. Okay. So pertaining to not my arbitration, but my actual judgment award, right?
Mm-hmm.
Actually, there's two questions now. Okay. So if I wanted to convey or assign a certain amount of that judgment into an insurance product, is that something that someone could help me with?
Yep. If you go back and watch that 6-minute video I did this morning about 10 times, you will know.
No, I did watch it this morning, but I did watch it. I enjoyed that. The DTC.
Yes.
But, okay.
Watch that 6 minutes 7 times, and then come back to that question, and you'll be telling me what you need.
Now, also on the 1098F,
correct.
We can use that for the arbitration awards as well, correct?
You can. I want you to not lose track of the fundamentals. Insurance side is the DTC side. Reinsurance side is the DTC side. So there's going to be a certain type of forms to put things in positions, and there's going to be a certain type of forms you're going to use that position. We're going to go back to the lesson today. I don't know how many folks have ever heard that presentation before. I play it quite a few times, but every time you listen to it, you'll learn something. If you do this right, you get to use the money in 2 different places at the same time. So if you put something into Chris, you're able to use it somewhere else at the same time. Make that work for you. That's what the insurance is there for. Like, if you go and get, I'll give you an example. One of my fiduciaries has an insurance policy with Travelers. Okay. If you check the credit rating of Travelers Insurance, and if they are not below the insurance standard, which means they probably are a high-rated insurance house, well, you get to use those credentials on your next application. Let me say this slowly.
No, I caught that because I was going to ask. I wanted to have that conversation probably because where my judgment is,
right?
They have a rating,
right?
And so I have that same rating,
right? So there's a form you need to use that. There's a form. Your answer to what you do X, Y, and Z is, Mr. Bay, what form should I use for this variable annuity trust? What form should I use for this irrevocable trust? What form should I use when I'm trying to stay CECL compliant but I'm dealing with an LLC? Then we get to the meat and potatoes.
So those will be the core documents?
Well, those are going to be, remember, it's insurance and reinsurance. There's a form for everything.
Okay. I'm going to ask the question again, but I'm not going to answer on the air. But I got you. I need to know what forms. I got you. I understand. Thank you for your time.
Got you. All righty, Big Joe. All right. Look, I appreciate everybody's time and energy. This has been an awesome class. I got a little bit of daylight left, so I got to continue to crack this stuff out through this automated underwriting software that we're using. If you haven't already and you have already gone into your submissions, you should have already filled out your Apex Capital KYC and your 1098F. Once you have that, The system is going to do what it do. Some of you guys are probably going to get invoices. Some may not. The invoices are basically calculating what is going to be necessary for them to point this information to the next instance. I want you to understand, and this is a recap. Everything that you're doing that you want to use in a public obligation, it will be, in my professional opinion, that you use an insurance form as a cover. You know, if you got that money transmittal, you know, like you got the transmittal letter, you got the UCCs, and then you got the money transmittal bond, then you probably want to have an insurance form on top of that. So when you talk to anyone in the public about all of that jazz, you can talk to them about insurance. Then when you're ready to move stuff with the 1098F and the K1s and this, that, and the other, and everybody who's got licensing or getting all warm and fuzzy, you're going to stick you another type of insurance form on it. So when you start talking to these licensed individuals, if you're licensed, you got to be what? Bonded and insured. So you're presenting your insurance, which has all of those intricacies inside. Now it makes it easier for you to convey, because both the public, listen to what I'm saying, both public institutions in both scenarios that I just explained can accept insurance, and they can definitely accept reinsurance. Hopefully you learned something. Go back to this particular course. I will put the link in Bitrix where you'll be able to go back to this class on Blog Talk Radio and listen to this to your heart content. Remember, all I'm offering is the truth, nothing more, nothing less. And if you listen long enough, you definitely will learn something. And with that, I'm going to say peace and love, family. Peace and love.